Hey folks, Dave Ceruolo, real estate, probate, and elder law attorney. In this video, we're going to talk about 3 great ways to plan if you have small children. If you're on YouTube, be sure to hit subscribe as you watch. Stay tuned. Let's say you have small children and you want to create a will. What do? Well, first off, folks, you understand that a will is a written legal document that disposes of your assets at the time of your passing, disposes of your stuff. Inside your will, you have the ability to create a guardian for your children while they are still minors. So this is a person that's going to take care of the persons of your children if your spouse is no longer with us at the time of your passing, right? Now, also you have the ability to insert testamentary trust language, a trust inside your will, which will handle your money on behalf of your children when you pass away and if your spouse is no longer with us. You would appoint a trustee, a manager of the trust, somebody of high responsibility to care for your assets while your children are below a certain age, usually 25, 35, and that trustee will have the ability, full discretion, to distribute money as the children need it for their care and well-being. Dave Ceruolo, CeruoloLaw.com. So what's an UTMA account? Well, folks, UTMA stands for Uniform Transfer to Minors Act, and with such an account, a loved one, a parent, called the custodian, can establish an account with the bank for their minor child under the name of the child with that child's social security number. Now, the assets inside the UTMA account are considered part of the custodian's estate until the child reaches age of majority. Once the child reaches age of majority, the child has access to those assets. Now, while those assets are being managed by the custodian has a fiduciary responsibility to the account. They have to manage those assets reasonably, make investments as they see fit, which are reasonable. They cannot commingle those funds with their own, and they can't spend those funds on their own debt, on their legal debt. Now, tax-wise, there's a tax benefit to the child because the assets inside that account are typically taxed at the interest or at the rate of the child. Dave Ceruolo, CeruoloLaw.com. So what's a special needs trust? Well, folks, in my past videos, I've explained different types of trusts that are out there. A special needs trust is normally created by parents of a child that is not competent to handle their own assets or their own money. And in these types of trusts, the parent usually will appoint themselves as a trustee or manager of the trust, and it will be for the care of that child. So now assets can be placed into the trust, and the parents can care for the trust or the assets inside the trust and the child without affecting the child's benefits the child may be receiving at that time. The other thing that can happen is that the parents can appoint another sibling of that child to be trustee or manager of the trust. And these types of trusts have to be managed in a certain way. For instance, money cannot be given to the child being cared for. Money cannot go into that child's name directly. Dave Ceruolo, CeruoloLaw.com.